لا إله إلا الله محمد رسول الله.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على سيدنا محمد خاتم الأنبياء والمرسلين، صلوات الله وسلامه عليه وعليهم أجمعين. السلام عليكم ورحمة الله تعالى وبركاته. أهلا وسهلا ومرحبا بكم. Welcome you back to our class on Imam al-Saqqaf's Mukhtasar Al-Fawa'id Al-Makkiyya, the essential principles and method of the Shafi'i school. This class will cover the categories of the Mufti, covering the categories of the Mufti and their roles in issuing legal rulings within Islamic jurisprudence or sacred law, bi'idhnillah ta'ala. The course outcomes: number one, we would like to achieve a comprehensive understanding of Islamic jurisprudence, to attain a mastery of scholarly etiquette and ethics, and familiarize ourselves with key Shafi'i texts and terminology, as well as to have enhanced spiritual and intellectual growth, bi'idhnillahi ta'ala. In this lesson, we focus our attention on pages 43 to 44, covering the categories of the Mufti, bi'idhnillahi ta'ala. Some of the key concepts in this lesson includes mujtahid mutlaq, which refers to a person who is able to make ijtihad and apply himself intellectually on the original sources of the law, including the Quran and the Sunnah, as well as employing other means like qiyas and other methods of usul to arrive at the furu', to arrive at the detailed laws of Islam. Mutlaq is unrestricted, meaning he's not a mujtahid in a lesser sense, such that he relies on other mujtahidun for certain aspects, but rather unrestrictedly he's an independent reasoner of sacred law. Then the concept of ijtihad is one's intellectual endeavor in trying to understand sacred law and make sense of sacred law. Tarjih refers to the concept of giving preponderance, right? So if you have two or more views, you have two or more contending views, and they are vying for the spot of being the actual view of the school, then you have a scholar doing what is called tarjih, or giving preponderance. And there's various ways in which they do this, but when they're trying to make the decision between one of a few choices, the two most ubiquitous or most common forms of giving preponderance to one view over the other are akthariya, majority, and quwwatud dalil, right, strength of evidence. So sometimes a scholar may give the preponderance or tarjih based on the opinion that is held or supported by the most number of reliable scholars. On the other hand, they may resort to quwwatud dalil, in which they go back to the evidence in question and apply themselves in that evidence to try to understand that the evidence is stronger supporting one view than it is the other view, and they would thus make tarjih accordingly. And then finally, we have a mufti, sometimes translated as a jurisconsult, and that refers to somebody who passes rulings of sacred law when asked to do so. So the way they pass rulings is not in the form of a judge passing a decree in a court, but rather a jurisconsult gives a legal verdict that is non-binding. Non-binding means that there's no enforceability of that law on that person. They come to the mufti voluntarily, they seek a fatwa voluntarily, and they act according to the fatwa voluntarily. So that's the mufti, as opposed to a qadi. A qadi makes a legal verdict within the space of a courtroom. So this is qada, and that legal verdict, when given by a qadi, is enforceable because the court can enforce that individual to apply that ruling, as is the case with other courts in the world. Wallahu subhanahu wa ta'ala a'lam. So those were some key concepts, something that we wish to add in our lessons going forward, bi'idhnillahi ta'ala. So with that, we commence with the first section that deals with aqsamul mutafaqqihin, the categories of those studying fiqh, the categories of the scholars of fiqh. قال في نشر الأعلام, in this text نشر الأعلام, there's some bibliographical information in the footnotes that you can refer to here. He says ثم الناس بالنسبة إليها, then the people in relation to it, يعني الفروع, in relation to the branches of the law, the detailed laws, al-ijtihadiyya, the type of furu that requires ijtihad. People are qisman. There are two types. Mujtahidun mutlaqun, there is the unrestricted mujtahid, and ghayruhu, there's others. So looking at this diagrammatically, we'll see that in relation to al-furu al-ijtihadiyya, right, where there are detailed laws, okay, the difference between fiqh and usul is that fiqh deals with the detailed laws and usul deals with the summarized or comprehensive laws. So al-ilmu bi-ahkami al-shar'iyyati al-muktasab min adillatiha al-tafsiliyya. Al-ilmu, it is the knowledge of al-ahkam al-shar'iyya, the laws of sacred law, or basically Sharia law. Al-muktasab, that is derived min adillatiha, from its evidence, at-tafsiliyya, in detail. So that's essentially what furu' refers to, as opposed to usul, where it is derived al-ijmaliyya, it is derived in a summarized form. So furu' essentially means what we learn when we study fiqh, when we study Islamic law. And in relation to Islamic law, there are two types of people. Either the person is going to be a mujtahid mutlaq, an unrestricted mujtahid, or he's not going to be an unrestricted mujtahid. As for al-mujtahid al-mutlaq, the unrestricted mujtahid, قد تقدم أنه يعمل باجتهاد نفسه. We have already explained that this individual will act according to the ijtihad, he will act according to the intellectual application of himself, meaning his own intellectual pursuit and study. وَلَا يَجُوزُ لَهُ التَّقْلِيدُ, and it is not permitted for him to make taqleed. In other words, it is not permitted for the unrestricted mujtahid to follow anyone else because he is capable of ijtihad himself. So that's in relation to the mujtahid mutlaq. Now remember, there were only two. Either you're a mujtahid mutlaq or you're not. Okay? So based on this, we can add to the diagram that the mujtahid mutlaq يعمل باجتهاد نفسه, he will act according to his own ijtihad. ولا يجوز له التقليد, and it is not valid for him, it is not permitted for him to follow anyone else in this regard. Okay, so you have a summary over here, and then we proceed to the next bit of text. Now, غيره, the other person. The other person, qisman, there's two categories. Either he's going to be متقيد بمذهب, is either going to be working and operating within the parameters of a particular school of thought, أحاط بغامضه وجليله, having encompassed the depths and extent of that particular madhab, وفروعه وأصوله, having covered the detailed laws as well as the legal theory of that particular madhab, ويمكن من التخريج عليه, he has the capability of making takhrij, of verifying, of ratifying, of checking, of following up, of investigating in that madhab. وَالتَّرْجِيحِ لِأَحَدِ أَقْوَالِهِ, he also has the ability to make tarjih, right, to decide between various opinions within that madhab, لِأَحَدِ أَقْوَالِهِ, to one of its views. And then if you are not of this category, مُتَقَيِّدٌ بِمَذْهَبٍ, then you would be, if you are not able to do what is mentioned here, as in having the knowledge of the entire madhab, the furu and the usul, and having the ability to make tarjih, right? If you are not of that category, then you would be وَغَيْرُهُ, somebody else. So if you can look at this diagram over here, we're just building on from what we had previously. So previously we said you have al-furu al-ijtihadiyya, you are either a mujtahid mutlaq or you are not. Now we are adding on. Still we have al-furu al-ijtihadiyya, you are either a mujtahid mutlaq who should act according to his own ijtihad, or you are not, غيره. Now as for the person who is not, he is either going to be muqayyid bi madhabin, he's either going to be restricted by a madhab or he's not. Now if somebody is not restricted by a madhab, then of course they have to apply themselves according to the way that they understand sacred law. Now, that means that the person is going to be left with the responsibility, the taklif, to follow the laws of Allah subhanahu wa ta'ala in a way that they find suitable. How are they going to do that? Allah knows best. But the reality is, if you're a mujtahid mutlaq, of course you can do that. But if you're not a mujtahid mutlaq and you're not restricted to a particular madhab, that means you are following the teachings of a mujtahid mutlaq or who you believe to be a mujtahid mutlaq. So some people follow individual scholars, others follow contemporary scholars and the like. But for most traditional students and scholars of Islam, Ahlul Sunnah wal Jama'ah, they follow a madhab. So considering that, غير مقيد بمذهب, we're not really going to explore this angle further. But the person who is operating within the framework of a madhab, either he has ahliyatun litarjih. He's either got the ability to make tarjih, meaning he can give preponderance to some views over others, or he's not of that category. Now, if you think about the Shafi'i school of thought, who has the ability to make tarjih? You are looking at the likes of Imam Nawawi and Imam Rafi'i, and you are looking at the likes of Ibn Hajar and Imam Al-Ramli, and perhaps some of the other scholars of the commentators of the Minhaj of Imam Nawawi, rahimahullah ta'ala. Perhaps you can add to it Imam Subki and others. There were scholars who, even though the tarjih is not necessarily taken as the official tarjih of the madhab, right? That's reserved for Imam Rafi'i and Imam Nawawi and then Ibn Hajar and Imam Ramli. But within the Shafi'i school, there were others who also had their own personal views. So you have Imam Nawawi who has his own personal views in addition to the madhab. You had Imam Subki and others also who had their personal views in addition to the madhab, and those are distinct. So such individuals have ahliyatun litarjih. They have the ability to decide between various opinions of the madhab and act accordingly. Now, for such an individual, he says, فَالْمُتَّصِفُ بِذَلِكَ, the person who is of this category, he has the ability for tarjih. يَعْمَلُ فِي حَقِّ نَفْسِهِ, he would act for himself بِمَا اخْتَارَهُ, with what he chooses. Now, this word here, بِمَا اخْتَارَهُ, is a word that is going to be important down the line as well, because from this we learn that there's a phenomenon known as the ikhtiyar. Apologies for my handwriting. Ikhtiyar. So you have the ikhtiyar of Imam Nawawi, for example, and you have the ikhtiyar of others. What this means is that in spite of the allegiance to the madhab, right? They are allied to the madhab, they apply the madhab, they are scholars within the madhab, still they have this ahliyah, they have the ability to check things for themselves and make decisions for themselves within the framework of the madhab. Sometimes they end up with their own private views. So in the most common example of this in the Shafi'i school would be that of Imam Nawawi rahimahullah ta'ala and his ikhtiyarat. So if we read the Minhaj, we find that he will tell us what the madhab is, but then he will also tell us what his own personal view is sometimes, right? If it differs, of course, from that of the madhab. So he would act according to that for himself. So that's the first point. A person who has the ability for tarjih, right, would act according to his own preferred view in relation to himself. Min haythu dalil, and he will act accordingly based on evidence. Al-aslah, what is the strongest and most suitable evidence. أو القياس, or we will apply analogy. وله إن كان قاضيا القضاء به. And if he happens to be a qadi, right, a judge, then he can pass a ruling according to his opinion as well, because he has the ability to do so, and Allah subhanahu wa ta'ala knows best, right? So that's the person who is muqayyad bimadhabin and he has ahliyatun litarjih. Naam, but we proceed from there. وَإِنْ كَانَ مَرْجُوحًا عِنْدَ أَئِمَّةِ الْمَذْهَبِ, he can even do so, what we just described, meaning he can even apply his own view, even if that view is marjuhan, is not preponderant. Marjuh means that you have two or more views. The one is the rajih, right? The rajih means that it is the preferred view or the preponderant view. And then you have the opposite of that, which is the marjuh view. So even if the opinion that this particular scholar, who are we talking about again? We are talking about somebody who is muqayyad bimadhabin and he has ahliyatun litarjih. if he passes a view, or if he acts on a view, or if he gives qada according to a view, even if that view is the opposite of the preferred view in the madhab in question, عند أئمة المذهب, by the scholars of that school, إذا ترجح عنده بدليل جيد, as long as he has this view, he holds this view because he believes it to be preponderant based on its excellent evidence. لم يشرط عليه لفظا ولا عرفا الحكم بذلك المذهب. So in his case, he will not be required, he will not be held, neither in terms of his word nor in terms of custom, to pass a ruling according to the madhab, right? He's following the madhab, he's muqayyad bi madhabin, but he has ahliyatun litarjih, and he believes that in this instance and in that instance, the view that he prefers is stronger in terms of its evidence than the view of the madhab. He is not obliged to pass a hukm. He should not pass the hukm according to the madhab. He should pass the hukm according to his own view for his own personal practice, as well as for qada if he so chooses, right? So there's his personal practice, there's qada, but not for ifta. As for ifta, or rather I shouldn't say and not for ifta, but as for the madhab remains the madhab. This is just this particular scholar's own view. We read further bi'idhnillahi ta'ala. He says, فَإِن قَضَى بِهِ, if he passes judgment according to this non-preponderant view, مَعَ اعْتِقَادِ مَرْجُوحِيَّتِهِ, if he passes qada according to the madhab with a non-preponderant view according to him, while he believes that the view of the madhab is in fact not the preferred view, right? That it is the marjuh, right? He believes that the madhab is the marjuh. So if he passes qada, if he passes a judgment according to the madhab, which he believes is marjuh, أو شرط عليه عند التولية, or he was instructed or coerced to stick to the madhab at the time of being appointed as the mufti or as the overseer or as the judge. ألا يحكم بخلاف المذهب, he was told you should not judge in contradiction to the madhab. You must stick to the madhab at all times. فحكمه باطل, and if he still then judges according to the madhab, then his ruling in relation to the madhab is that it's going to be batil, null and void. يجب على القضاء, it would be compulsory upon the other judges, نقضه, to nullify that judgment, وعلى المفتين, and upon the jurisconsults, the muftis, بيان بطلانه, they should explain its invalidity, right? So very simply, you have a scholar, he's working within the parameters of a madhab, but he is no ordinary scholar. He has ability to make takhrij, tarjih, etc. in that madhab. He's an Imam Nawawi, he's an Imam Rafi'i, he's a Ibn Hajar al-Haytami, he's a Imam al-Ramli, etc. They know the madhab, they've understood the madhab, and they have ability within the madhab. If they believe that the madhab says this, but their opinion based on a strong evidence differs from that of the madhab. According to the madhab, it is A, but according to his view, it is B. If he still rules according to the madhab, despite believing that B is the correct answer, then his ruling is basically null and void, and it becomes necessary to rectify him in this regard, and that's essentially what Imam al-Saqqaf is saying in this section over here. Now we proceed from there bi'idhnillahi ta'ala to the next section. He reads, وَإِن كَانَ مُفْتِيًا, and if that same individual, that person who is a scholar restricted in the school of thought, but has the ability to decide between opinions within that school, if he happens to be a mufti, passing fatwa within the madhab, وَقَدْ تَرَجَّحَ عِنْدَهُ ذَلِكَ الْقَوْلَ الْمَرْجُوحِ, and according to his understanding and ijtihad, the non-preponderant view or the unpreferred view in the madhab is in fact the correct view, فَلَهُ الْإِفْتَاءُ بِهِ, then he can also pass fatwa with it. That means he can still pass a legal verdict with it as a fatwa. We've already discussed qada, right? So he can give a fatwa according to it. However, there's a clause, إِن بَيَّنَ لِلْمُسْتَفْتِي قَائِلَهُ, as long as he clarifies to the person seeking the fatwa, the mustafti, right? The mufti and the mustafti. Who's the mufti? The mufti is the jurisconsult. The mustafti is the person seeking, right, jurisconsultation. So, in this case, the person can still give fatwa accordingly, but he must explain, look, this is not the madhab, this is in fact the opinion of Imam Nawawi. Or this is not the madhab, this is the opinion of the scholar. Right? So he must explain that. لِيُقَلِّدَهُ, in order for the mustafti, the person seeking the fatwa, to make taqleed, in order for the mustafti to make taqleed. قَلَّدَ يُقَلِّدُ تقليدا تقليد, right? تقليدا صحيحا. Oh, there's the word taqleed over there. Didn't need to write it in. Tamam. Okay. So taqleedan sahihan, in order to follow him correctly, appropriately, right? وَإِلَّا, if he does not clarify to the mustafti who exactly is the qa'il, who exactly is the origin of this particular fatwa, lam yajuz dhalik, then it would not be permitted for him to pass a fatwa accordingly. Now remember, this person is restricted to a madhab. When somebody comes to him and they're asking him for a fatwa, in all probability they are asking him for the fatwa in relation to the Shafi'i school. So he can't pass a fatwa giving the impression that this is the Shafi'i school's view if it's not. So he can pass a fatwa that's not the Shafi'i school based on his own ikhtiyar, but he then needs to clarify that, look, this is not the madhab, this is Imam Nawawi's view, or this is that scholar's view. So that's basically what he's saying here. Wallahu subhanahu wa ta'ala a'lam. We proceed, inshaAllah. وَغَيْرُ الْمُتَّصِفِ بِمَا مَرَّ قِسْمًا. And others who have not been described in the previous information, there's going to be two categories. So now remember, we are looking at al-furu' al-ijtihadiyya, people in relation to fiqh. You're either a mujtahid mutlaq or you're not. Then you are either restricted to a madhab or you are not. Then if you are restricted to a madhab, either you have ahliyatun lit-tarjih, you have the ability to decide between views within the madhab, or you don't have such ability. لَيْسَ لَهُ أَهْلِيَّةٌ or لَيْسَ لَهُ أَهْلِيَّةُ التَّرْجِيحِ. The person does not have the ability to make tarjih. So that's what we are speaking about now. وَغَيْرُ الْمُتَّصِفِ بِمَا مَرَّ قِسْمًا. You're going to be one of two types. فَقِيهٌ فِي مَذْهَبِهِ. Either the person is going to be a faqih, a scholar of fiqh in the madhab. عَرَفَ الرَّاجِحَ وَضِدَّهُ. He knows the rajih. He knows what is the preponderant view, right? So here's the word preponderant again, or preferred. وَضِدَّهُ, and he knows the did, the opposite of the rajih. What would be the opposite of the rajih? Let's see if you're paying attention. We spoke about it a moment ago. What is the opposite of the rajih? You have the rajih, which is the preponderant, and that which is the unpreferred view, not the chosen view, that would be the marjuh. The easiest way to remember this, of course, is that rajih is on the scale of fa'il and marjuh is on the scale of maf'ul. Tamam? So, based on this, he knows the rajih of the school. He knows which opinion is the preferred view of the madhab. وَضِدَّهُ, and he knows the unpreferred views as well. But he knows them بِمَحْضِ التَّقْلِيدِ, by mere following. He only knows them by following. He doesn't have more independent ability than that. وَغَيْرَهُ, and if he's not of this category, if he's not a faqih in the madhab, then he's going to be وَغَيْرَهُ, somebody else. فَالْمُتَّصِفُ بِذَلِكَ, so the person who is described with that, يعني the person who is a faqih in the madhab and he can understand the rajih and the marjuh, but not having the ability, لا يفتي, this person cannot give a fatwa إلا بالراجح, except with the preponderant view, وإلا, and if not, لم ينفذ قضاؤه وفتواه. If he does not give a fatwa according to the rajih, then his qada, his judgment, and his fatwa, his legal ruling, will not be carried out. لم ينفذ. Tamam? So we spoke about the person who had ability of tarjih, this discussion, this faqih, was somebody who does not have the ability for tarjih. In his case, فالمتصف بذلك لا يقضي ولا يفتي إلا بالراجح. He cannot give a court ruling nor a non-binding ruling except according to the preponderant and preferred view of the school. وإلا, but if he doesn't do that, لم ينفذ قضاؤه وفتواه, then his qada and his fatwa will not be carried out. Now it might seem strange at first. Who are we talking about? We are speaking about not the likes of Imam Nawawi and Imam Rafi'i and Ibn Hajar and Ramli. We are speaking about scholars who subscribe to the madhab, but not as independent reasoners within the madhab, rather as muqallidun. They are followers of that madhab. They know the school, they know the rajih and the marjuh, etc., but they don't have ability to the point where they can now make tarjih and say, this is the preponderant view, as opposed to what Imam Nawawi said, this is the preponderant view, as opposed to what Ibn Hajar al-Haytami said. Tamam? Now this ability being absent means that this person is a follower of the madhab, like other people are followers of the madhab. Only difference is they have knowledge of the madhab. So now when they give a ruling, they must give a ruling according to the preponderant view of the madhab. Right? That's the general rule. Now that may seem strange because some of you may already know that in the Shafi'i school, in fact, all of you should know because we did this in this kitab. In the Shafi'i school, you may follow the marjuh view in the madhab. What we are speaking about here is not what you may do and what you may not do in your personal practice. We are speaking about the mufti, right? We are speaking about the mufti and the scholar who's going to be passing a fatwa. He needs to understand the parameters within which he's working. In the capacity of passing a fatwa, right? In the capacity of being employed as a mufti or being appointed as a mufti. If he has this ability, then this is how he should pass the fatwa according to the rajih of the madhab. That's the general rule. That seems a bit restrictive considering the fact that the madhab is a bit wider than that. So Imam al-Saqqaf carries on and he tells us, Na'am lahu dhalik. Yes, he can do that, meaning he can give a legal court ruling or a non-binding legal ruling according to the marjuh. It's the opposite of what we just said, right? لِحَاجَةٍ أَوْ مَصْلَحَةٍ عَامَّةٍ. But he can only do so because of a haja, a need, أو مَصْلَحَةٍ عَامَّةٍ, a need or a general form of difficulty, something that's generally considered to be difficult. And Allah subhanahu wa ta'ala knows best. Now naturally there's going to be a certain level of subjectivity in this. I'm just thinking out loud. As an example, we understand that there's certain times where Allahumma salli ala Sayyidina Muhammad. I don't know if I should mention this example because it may just cause more harm than benefit. But the point here being, you are restricted to passing a ruling according to the rajih of the school, if this is the mufti that you are dealing with, or if this is the mufti that best describes you. So that would be generally most Shafi'i scholars today, if not all Shafi'i scholars today, who have studied the Shafi'i fiqh to the highest degree. Still, I don't know of a Shafi'i scholar alive who would consider themselves as having the ability to make tarjih within the madhab like Imam Nawawi did. So they would be restricted to the madhab and passing fatwa according to the rajih or the preponderant view of the madhab. This is the rules of fatwa. Now, when are they allowed to deviate from the rajih and pass a fatwa according to the marjuh? And the answer is when there is a need to do so, when there's a haja, right? And when there's maslaha amma, where there's a general public interest in order to do so. This allows a certain level of structure for fatwa. If this system is not adhered to, then what you're going to have is a system of sort of Allahumma salli ala Sayyidina Muhammad, where the mufti can just go through any opinion in the madhab and put that forward as this is the madhab. That's what it would really amount to. Unless he of course clarifies and says that this is not the madhab, but this is my fatwa. But he cannot do that because he's not within that category, like we've explained earlier on. What he can do is, he can give fatwa, he can pass a legal ruling and make qada according to the rajih of the school, the preponderant or preferred view of the school. And when a need arises or there's some general public interest, then he may deviate from that and pass a ruling according to the marjuh view. Now, generally speaking, this is going to be done with consultation and a panel of scholars, as opposed to just being a single scholar making such a decision, and Allah subhanahu wa ta'ala knows best. He gives an example in the text, and the example is a bit dated, but nonetheless, كحكم شافعي بصحة تزويج صغيرة ثيب. Like a Shafi'i ruling that it is valid to get a young girl who had already been married again. فقدت المجيرة لحاجة النفقة ونحوها. Okay, basically because she needs nafaqa, she's in a desperate situation, so let's look at the validity of that marriage. So I'm not going to get into that as an example, but just to understand that when there is a need, you can do what has been described here and give fatwa and qada according to the marjuh, and Allah knows best. He says, إن لم يشترط عليه الحكم بالمذهب. Now, the tricky bit here is, as opposed to the scholar who could make tarjih, this scholar cannot. So, if he was appointed as a mufti, and he was instructed at his appointment that you should only pass fatwa according to the Shafi'i school, now he no longer even has the ability to pass a fatwa according to the marjuh for a need, right? He still has to pass the fatwa according to the rajih because he's been compelled, or he's been contracted to do so. وكحكمه بنحو شهادة فاسقين عند عموم فسق الشهود. Or considering, you can give a judgment that witnesses are just, witnesses are valid witnesses, even though they are sinful, even though they are open sinners. Why? عند عموم فسق الشهود. At times when basically everybody is going to be a sinful witness. لمصلحة العامة, because this is public interest. If you don't allow a sinful witness in a time when everybody is sinful, then you're going to be essentially nullifying the functionality of the court, right? So because of the public interest, we maintain the validity of witness. That's something that can be done despite the rulings that generally exist, and Allah knows best. وهي توقف أداء الحقوق إلى أهلها غالبا على ذلك مع بيان قائله أيضا. And the way that this would be done would be to pause fulfilling the rights, whoever it belongs to, under most circumstances, based on what we just said, while explaining who said this as well. So this is essentially what we are looking at in the slide here. Just to revise, in terms of furu' al-ijtihadiyya, either you're a mujtahid mutlaq or you're not. Either you are restricted to a madhab or you're not. If you are restricted to a madhab, either you have ahliyat tarjih or you don't have ahliyat tarjih. The rules for the person with ahliyat tarjih has been discussed. They are mentioned, some of them are mentioned here. And then the rules for the person who does not have such ability, some of them are mentioned here. We proceed bi'idhnillahi ta'ala to the next section. So now we are dealing with وَغَيْرُ الْمُتَّصِفِ مِمَّا مَرَّ. Somebody who doesn't qualify to be anywhere on the table that we showed previously. Meaning, he's not a mujtahid mutlaq. He's not a mujtahid within the madhab. He is restricted within the madhab, right? So he does not have ahliyah of tarjih. Sorry, he's not a person of ahliyah. He doesn't have the ability to make tarjih, nor does he fit into this category, because this category doesn't have ability, but they know the madhab. They know the length and the breadth of the madhab, right? Look, فقيه في مذهبه عرف الراجح وضده. He knows the preponderant view, the preferred view, and he knows the opposite, even though he knows them by merely following them. Now, when we speak about this next person, وَغَيْرُ الْمُتَّصِفِ مِمَّا مَرَّ, somebody who is not described with what had passed previously, مُتَفَقِّهَةٌ وَغَيْرُهُ, is going to be the type of faqih who does not know the tarjih of the madhab. He does not know what is the rajih and what is the marjuh, even though it be by taqlid. He's still learning, right? His knowledge of the madhab still needs to be developed. So in the instance of this person, فَالْمُتَفَقِّهُ لَا يُجَاوِزُ مَا عَلِمَهُ. A person learning fiqh, a person still studying fiqh, they should not go beyond the limits of what they know. عَمَلًا فِي حَقِّ نَفْسِهِ, whether that be in relation to their own personal practice, وَإِرْشَادًا لِغَيْرِهِ, or whether that be guiding others, right? So he's not supposed to be giving fatwa at all. He's not supposed to be giving legal verdicts at all. He's still studying. He doesn't know the madhab thoroughly. But he may offer irshad. He may offer guidance. So if somebody comes and they ask, you're studying fiqh, aren't you? Tell me, if in the salah, should I do this or should I do that? The person will say, well, I studied that. You should do that. What's that called? It's not called a fatwa technically. It's called irshad. In practice, it's the same as a fatwa. But, there's the difference is that a fatwa has certain rules that we've just discussed and certain parameters, whereas irshad is a bit more flexible in terms of the rules, right? So either that is going to be the case, وَلَا نَظْرَ لَهُ فِي رَاجِحٍ وَلَا مَرْجُوحٍ, and this person, this mutafaqih, this person studying fiqh, لَا نَظْرَ لَهُ فِي رَاجِحٍ وَلَا مَرْجُوحٍ. He has no view, he has no opinion, he has no knowledge really of what the rajih, the preferred view, and the non-preferred view of the madhab is. Tamam? وَلِلْعَامِ, and as for the layman, he can al-i'timadu, he can rely ala qawlihi, he is allowed to rely on the opinion of this faqih, of this person studying fiqh. In ghalaba ala dhannihi, if he thinks, if it is preponderant by him, أنه قد أدرك ذلك الحكم, that this faqih, this person studying fiqh, he in fact does know what he's talking about. He does know the hukm الذي قاله, which he is relating. So, for us, right, we're studying fiqh, we know some rules of the madhab, but we don't know all of the rules of the madhab. We know some rajih, but we don't know all of the rajih views. We know some of the marjuh views, but we don't know all the marjuh views. Now somebody comes to us and they ask us, can I do this? Can I do that? Is this permissible? Is this lawful, etc.? What do we do? Do we not say anything? No, under those certain circumstances, we may offer what is called irshad, guiding the person to what we believe to be correct. And the ami, right, the person from the general public, they may take that view and they may practice upon that view if they believe that the alim that they've asked knows what they are talking about in that respect. Now, for the general public, it may be a bit tricky for a complete novice to be able to make such a distinction, to be able to make such a judgment. Remember, an alim generally has a seat of authority, and a beginner is quite intimidated by such a position, such a seat. And if that alim doesn't know what he's speaking about, or is corrupt, or has nefarious motives, it's very difficult for a complete novice to know this. So I would advise that to make such a decision, the ami, the person from the general public, should ideally first ask a variety of scholars, a number of scholars, at least 3 trustworthy, reliable scholars. How do you know who are reliable scholars? Now, this you can ask around, you can ask your local imams, etc. But what you are looking out for is, you are looking out for qualifications. The person needs to be a qualified alim, right? That's the first thing. And I would say the second thing is that they are recognized as reliable by their peers, right? So there are other scholars who are also reputable, and they can testify to the veracity, to the reputation, to the reliability, to the knowledge of the scholar. Then I would say you can take that scholar and trust that scholar. But don't just make this decision based on which scholar is the most attractive, or which scholar has the best eloquence, or which scholar speaks the best English, or which scholar dresses the best. These are, of course, not important factors in that decision. Wallahu subhanahu wa ta'ala a'lam. So that was an important section on the different types of level of scholarship in Shafi'i fiqh. I leave you with a question, bi'idhnillah ta'ala. And the question is, when can a mufti who is a muqallid, يعني a pure muqallid, he doesn't have the ability for tarjih. When can a mufti who is a muqallid, it continues. When can a mufti who is a muqallid and knows the rajih from the marjuh, he knows the rajih from the marjuh, this doesn't say he has the ability of tarjih, it's saying he just knows the rajih and the marjuh, so he is a pure muqallid. When can he pass a fatwa according to the marjuh view, if at all? Right? So this is one of the few questions that you've been afforded to deal with underneath the quiz that is attached to every lesson. If you have not yet registered for this course, please do so. Registration details are on the screen. You can go to SeekersGuidance.org and log in or register an account with Seekers Guidance. Find the Mukhtasar of Imam Saqqaf's, or rather Imam Saqqaf's Mukhtasar Al-Fawa'id Al-Makkiyya, and register for the course. What this will allow you to do is, not only will you be able to get access to the lessons essentially for a lifetime, but you will also get access to specified quizzes that are designed to accompany each lesson, and they are designed to be able to test you to see your own ability and how much you've absorbed and understood of the information that has been shared. Allah subhanahu wa ta'ala a'lam. As a summary for this lesson, we've looked at pages 43 and 44, the categories of the mufti, and some guidance for the various categories. That brings us to the end of lesson number 9. Jazakumullahu khairan. Until next time, wa sallallahu ala sayyidina Muhammad. Subhanallahi wa bihamdi, subhanaka Allahumma wa bihamdik, nashhadu an la ilaha illa anta, nastaghfiruka wa natubu ilayk. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
لا إله إلا الله محمد رسول الله.